Good day to you and welcome to another Paddocks Club tutorial. Today I'm going to have a look at the recent changes to the regulations and particularly to the management rules prescribed under the regulations to the Sectional Titles Act and try and clear up some confusions that have arisen in this regard. There are four major issues, I think, at least ones that I've heard of. So let's look at the first one. Is there a limitation on the number of proxies that any person can hold? Well, the answer is no, there is not. Prescribed Management Rule 67 continues to apply and it contains no limitation. This prescribed management rule, despite contrary indications in newsletters and talks, has not been amended. The maximum of 2 proxies principle is something that exists, but it's in the Sectional Title Schemes Management Act, which hasn't come into operation yet. And when it does come into operation, it will come into operation in tandem with a set of regulations, which I'm guessing are going to deal adequately with the concerns that have been validly raised in regard to the effect of this limitation. Let's move on to the second one. Can all documents now be delivered by email or in some other digital format? The answer is no. The amendment to Prescribed Management Rule 39.2 deals only with the AGM pack, as it's called, those documents that have to be sent out for the purposes of the AGM and which accompany the notice. The amendment to Prescribed Management Rule 54.5, which has been cited as being part of this overall change, is not in fact relevant to delivery methods. So for documents other than the AGM pack, this particular permission to deliver by way of digital format doesn't apply. Let's move to the next one. Must owners now authorize special levies? The answer is no. Prescribed Management Rule 31.4 has been deleted, but Section 37.2a and 2b cater for special levies. They don't, as widely reported, require owner consent. All levies are raised by the trustees who must, under Section 39.1 of the Act, exercise the body corporate's powers. So there has been a change in that the codification of the necessity principle, which was in 4, has now been removed, but all the same principles still apply. You can only raise special levies when it's necessary, and the trustees take that decision. What is the deal with the appointment of Prescribed Management Rule 71 arbitrators? Well, 71.4 has been amended. It used to be that if the parties failed to agree on the identity of an arbitrator, the local registrar would appoint. That's been changed. It's now the Chief Registrar of Deeds in Pretoria. So managing agents, sectional title consultants, attorneys and others who wish to be appointed should now send their CVs, their details, to the Chief Registrar in Pretoria. I suggest that you mark it for the Chief Registrar's staff who deal with this sort of thing for their attention, and hopefully they will confirm that they have those details on record. Thank you very much for joining me for this Paddocks Club tutorial, and if you have any questions in these regards, please don't hesitate to ask them on the discussion forum.